Good afternoon and welcome to the DC Court of Appeals. As a general reminder, we ask that you mute all electronic devices or cell phones so as not to disturb this afternoon's argument. Thank you, and we'll be starting shortly. All rise. All persons have been dismissed before the Honorable Associate Judges now presiding over the District Court of Appeals. Draw near and give your attention. God save this United States and this honorable court. This honorable court is now in session. Please be seated and come to order.
Good afternoon, everybody. Thanks for being here, and to the parties, thanks for indulging the rescheduling. We really appreciate that. I'm Associate Judge Corey Beckwith, and I have with me my colleague, Associate Judge Josh Deal, and we are really grateful to have the assistance of our Superior Court colleague, James Kroll, today. We have two cases on this afternoon's calendar, and the first one is number 23 CV 977 TYROSHI Investments LLC versus US Bank and so forth.
Good afternoon, Your Honor. I'd like to reserve 2 minutes for rebuttal.
Sure.
Good afternoon, Your Honors, and may it please the court. My name is Ian Thomas, and I represent Appellant TYROSHI Investments in this appeal. We ask that this court reverse the judgment of the lower court in favor of US Bank for the following 3 reasons. First, US Bank's claims are time barred under the appropriate statute of limitations. Second, the lower court improperly applied the federal foreclosure bar, which is inapplicable to the claims in this case. Third, US Bank's argument that unconscionability barred the foreclosure sale is foreclosed by this court's decisions in RFB Property and New Penn Financial. Your Honors, the threshold question in this case is really whether US Bank's claims are timely. The lower court tangled with this idea and waffled back and forth essentially between 2 different statutes of limitations. The first contained in DC Code 12301A8, the catch-all limitations period that is a 3-year period. The second contained in DC Code 12301A1, which is a 15-year period that applies to reclamation of lands. Now, in this instance, the lower court essentially applied both. So as an initial matter, US Bank asserted claims against both my client as the purchaser of a super priority foreclosure and the seller, the condominium association. Early on in the case, the condominium association moved to dismiss all of the claims. And by the way, the claims are they're overlapping. So there's not separate claims for separate defendants. They're all interchangeable between the 2 defendants. Now, the lower court, in applying the statute of limitations, dismissed the condo association on the 3-year limitations period.
Oh, yeah, that's true, but for a reason that is inapplicable to TYROSHI. The reason that he said the 3-year limitations period and not the 15-year limitations period applied as the condo association is that the condo association is making no claim, no ownership claim on this land, whereas TYROSHI is. So, I mean, first, I don't think it's right that the trial court is being inconsistent. Second, I'm not sure why we would care. If he was right the second time, that's the one that's on review. So, I mean, I take it as an atmospheric point that the judge was having a tough time with this issue. But, you know, should we stick to whether or not the judge was right the second time?
Well, certainly, Your Honor. I think the second time the judge was wrong as well, though. And the reason is because at the heart of US Bank's claim, this isn't seeking to reclaim land. It's seeking to reclaim a contract right. So US Bank had a contract, or its predecessor in interest, I should say, had a contract right in the form of a lien on the property. And what happened through the super priority lien foreclosure was that contract right got extinguished by virtue of DC statute. So what essentially, in essence, US Bank is looking to do is not reclaim land that they already owned. The restatement on mortgages, this case is, this court's precedents in Chase Plaza make clear that the mortgagor doesn't own that property. What they're looking to do is reclaim a contract right, because from that contract right flows everything else. And so it's not reclaiming land, it's reclaiming a contract. And this court's precedents confirm that understanding, Your Honor. So in the Murray versus Wells Fargo case,
But I mean, I didn't understand that to being essential to your argument, so let me just press on it. Let's assume, and pardon me, I forget the property owner's name, was it Jenkins?
Gaines.
It's Gaines. A lot of cases involve similar fact patterns here. So Miss Gaines, after foreclosure, she waits, 5 years and says, that was wrongful foreclosure. I've got Fannie Mae here joining me to say the federal foreclosure bar precluded it. In your view, would that be a suit for the recovery of land, since she's not just seeking to recover a contract right, she is seeking to resurrect her one-time property interest?
For Miss Gaines, it might be a different analysis, Your Honor. I don't disagree with that point because Miss Gaines was the actual fee simple owner of the property. And so if she was dispossessed of that property, it might be a different analysis. But what we're looking at.
I mean, I get that it might be. I mean, do you think it is?
I think it is. I think it's a completely different.
Do you think that
analysis.
would be a suit for the recovery of lands?
I don't necessarily, I'm not positive that I would say it's a suit for the recovery of lands because the claim ultimately arises out of a contract again. Ms. Gaines would have been dispossessed of her property due to a deed of trust, which is a contract right. And so it's a suit based on the enforcement of a contract right. I think historically, when 12301A1 has been applied by this court, it has really been done in the context of adverse possession, not necessarily in the context of wrongful foreclosure. And this court, when they have looked at claims, even quiet title claims that are looking to set aside a foreclosure, they've applied the 3-year limitations period in A8. Murray versus Wells Fargo, most recently in Staub versus Wells Fargo, where this court essentially said it's going to be one of two. It's either the 6 under the federal foreclosure bar or the 3 under A8. So
When you say it's applied to adverse possession and not necessarily, you said, to these other kinds of cases, why the qualification? Is it because there is some case law out there suggesting otherwise?
not that I'm aware of, Your Honor. And I think the absence of case law that's relied on by US Bank is particularly telling here.
I think they've got one. I think they've got the DDC.
The Lancaster.
Lancaster v. Fox case.
Correct. But the Lancaster case is entirely distinguishable from the facts here. Lancaster, Judge Boasberg was looking at a motion to dismiss for failure to state a claim. In the context not of a super priority lien foreclosure, but some sort of foreclosure rescue scheme. And the facts of that case.
I gotta interrupt you there, counsel. In reading his opinion, Judge Boasberg observed the plaintiff sued to quiet title an action that at least in some parts seeks, quote, the recovery of lands, end quote. Why isn't that exactly what happened here?
Well,
Because it is in part the recovery of lands. I get your point that it's a contract right, but it's also a contract right for the recovery of lands. Isn't that exactly what we're talking about here?
It's not, Your Honor. And the reason why, again, with the distinguishing point in Lancaster is that it was the owner of the property that's making the lawsuit. So they had a possessory interest in the first instance. And second of all, Judge Boasberg didn't hold that the recovery of lands statute of limitations applied. What he said was, this is a motion to dismiss, and on the 4 corners of the complaint, it is unclear which applies. And so I'm not going to make a decision on, A1 versus A8. What I'm going to say is that there is enough dispute here that we are going to hold this off for another day.
But then how do you differentiate here where the trial court perhaps did have sufficient facts to be able to make that decision and decided, contrary to your client's interest, that A8 was applicable versus A1 or A1 was applicable instead?
Well, again, the difference here, Your Honor, is that there was no possessory interest in the property that US Bank initially had. US Bank's possessory interest came via a deed of trust that was extinguished by statute. So the only way US Bank gets to that possessory interest is they have to invalidate this claim or this foreclosure, that took place and that basically eviscerated one of their contract rights. Not a fee simple right, not a fee simple ownership right, but simply a contract right in the property. And I think that's really the key distinction here. And this court's acknowledged it. Again, most recently in Staub. Your Honor, Judge Deal, you've made clear and you're correct that a lot of these types of cases come before the court. Super priority liens are not a stranger to this court, particularly over the past few years. And Generally speaking, when this court has been called upon, and again, in the Staub case, to determine what that statute of limitations is, that limitations period has been acknowledged to be a 3-year limitations
Yeah,
period.
I guess I'm just wondering, I took you to be taking a stronger position, and here I hear you making a somewhat weaker position that hinges on the possessory interest. I would have thought if, there's all sorts of ways you can try to attack a conveyance of land. Sometimes, let's say, a seller was defrauded. The buyer made some fraudulent misrepresentations. They transferred the land to them. They thought for some amount of money that was never forthcoming. They realized it, and then they waited 14 years to sue to recover their land. I would have thought you said, well, that's a fraud claim. That's a 3-year claim. And we have cases that say that all over the place. Even though you could think of that as a suit to recover lands. What we say is, when we look at quiet title actions, that all of which, in some sense, seek to recover land, what you do is you look at what the underlying complaint is. And if it's a fraud, well, then that's 3 years. And if it's a breach of contract, well, also 3 years, unless the federal foreclosure bar applies a 6-year statute of limitations to that. If it's wrongful foreclosure, it's 3 years. And I thought your position, and again, just correct me if I'm wrong, was in the recovery of land statute is something where nobody's really disputing who has the title to the land. It's just it's an ejectment action is when 15 years applies. But you seem to be hinging everything on this possessory interest that strikes me as a weaker argument than you had been making.
Well, I apologize, Your Honor, because essentially what you were saying is exactly what our argument is it depends on the actual nature of the claims. And here, the nature of the claims, much like Your Honor was saying, in a fraud action, it's going to be an action for fraud, even though you're taking back land. Here, it's an action that's based out of a contract, right? A lien interest. That's really the case. You have to look at the actual nature of the claim. And I'll also point out, Your Honors, that when we're talking about case law on this point, the Talbot case, which is a century-old precedent from this jurisdiction that is binding, unlike the Lancaster case, says that the 15-year limitations period doesn't apply to when the power of sale is executed, i.e. a foreclosure. So there has been treatment on this. I admit there's nothing that's a lot more recent, or at least as explicit as Talbot is, that's more recent, but it has been tackled by this court in a decision that has precedential value. So, I mean, we would argue that it is a 3-year limitations period and that the recovery of lands does not apply, and the lower court was incorrect in doing that.
But I don't suppose in that case, I mean, I know we have cases on quiet title that apply 3-year statute of limitations to all manner of claims. In any of them, did we discuss, was it raised that maybe the 15-year statute of limitations for recovery of lands applies?
I'm not aware of one, and as I stated earlier, Your Honor, the most recent super priority lien case here and before this court that addressed statute of limitations is the Staub decision. And the Staub decision indicated 3-year limitations period or federal foreclosure bar, depending. But it seems to me, Your Honor, that there are a significant amount of authorities that would support the 3-year limitations period. And if you look at the nature of the claim, there is a property relation, certainly, but at the end of the day, the claim really sounds in contract, and it sounds in an equitable claim to restore a contract right, not a property right per se, or at least a real property right, I should say. But the lower court made a mistake also in applying the federal foreclosure bar. So statute of limitations is not the only mistake that the lower court committed.
Can I do before you? I know you want to jump to the federal foreclosure bar, but can I keep you on statute of limitations
Absolutely.
for a second? If I agree with you so far that this is not a 15-year statute of limitations, this is not an action for recovery of lands, but instead this is probably a wrongful foreclosure to which a 3-year bar applies type of claim. The parties didn't really brief this so much, but there's at least part, I believe, of U.S. Bank's claim is unjust enrichment that occurred within the 3 years before filing suit. So that at least part of their claim, a pretty small part, I would think, but I haven't tried to run the numbers, would still be alive, even if a 3-year statute of limitations applied as to the unjust enrichment aspect of their claim. And what's your reaction to that?
Well, Your Honor, if their claim was time barred to set aside the the foreclosure sale that my client took.
No, still unjust enrichment. We just said that in a case called Flagstar, where we kept paying the taxes. So even if
Understood.
we weren't the right owner and TYROSHI was the right owner, they were beneficiaries of us continuing to pay the property taxes. They weren't doing it. And now they're off the hook for all these. Let us recoup those amounts and then, disgorge the amount from them.
Understood, Your Honor. In that case, I think the lower court didn't analyze that at all. And I think it's something that's not really in the record before the court. And it would be something that I think would at least be worthy of remand for the.
It might not be in the arguments before the court either. It's not really hashed out in the briefs at all.
I tend to agree with that, Your Honor. I see my time is quickly coming to an end, Your Honors. I'm happy to briefly discuss the federal foreclosure bar if you would like. So the lower court also erred in applying the federal foreclosure bar, and it did so for a number of reasons. Recognizing time is short, I'm going to try and run through them as expeditiously as possible. But first and foremost, it was never raised. And I think that really is the threshold problem here before we even get to the substance. So US Bank files a complaint. The complaint, which is required to provide a short, plain statement of facts upon which they're requesting relief on, does not reference HERA, does not reference the federal foreclosure bar, does not reference Fannie Mae. The parties brief summary judgment on multiple occasions, multiple dispositive motions. Not once is Fannie Mae, HERA, or federal foreclosure bar raised. They submit a joint pretrial statement that does not mention the federal foreclosure bar or Fannie Mae at all. On the eve of trial, they attempt to amend their complaint to add allegations on this point, and the court denies the motion. And in doing so, denies my client's motion to eliminate that argument, saying it was moot. 2 days later at trial, court lets them go right in on the federal foreclosure bar. And we would submit that that is, at that point in time, the argument's been waived.
Did you guys at that point renew, hey, Judge, so put aside the amendment of the complaint because, maybe it should have been dismissed at that point or granted summary judgment, but now we're at trial. And it seems to me your big complaint is, well, we asked that they be precluded from arguing this. And the judge said, well, that's moot because I haven't allowed them to amend their complaint. And then he permits them to argue it. At the point he permits them to introduce the evidence, do you guys say, wait a minute, Judge, why are you letting them do that? I thought we just secured a ruling saying you didn't need to rule on our request to preclude them from doing that on the basis that you weren't going to allow this, like it was irrelevant because it was outside of the complaint.
I believe that, and I didn't handle the case below, Your Honor, but I believe in the transcripts there is objection to that form of argument. The court, Judge Rigsby.
Wait, what do you mean? Can you be more specific?
I don't have the specific record site, but I believe it was in the first day of the trial transcript, Your Honor, when it was
You
raised.
said an objection to that form of the argument. You mean
I
that
believe that's-
content or
yeah.
that substance?
I believe that's right, but certainly Judge Rigsby recognized that he originally didn't allow the amendment because in his decision, he tackles the notion that he's now considering the federal foreclosure bar. And he very clearly addresses that point, right? That it wasn't raised. And he says, well, it didn't need to be raised. It's a theory of the case. You can raise a theory of the case at any time. But we would submit that that's an improper application of that kind of legal doctrine because we're entitled to at least have notice at bare minimum by the time we get to pretrial, what the issues are in this case and what we have to put on evidence of, which we did not have. So really what the federal foreclosure bar ended up being was trial by surprise. I also would submit that there's a standing issue here for US Bank. The reason being is that the statutory right is vested in Fannie Mae. And there is no evidence in the record that submits that either that right was assigned, if it could even be assigned in the first place. And for that reason alone, it's questionable whether they have standing, and US Bank has the obligation to prove they have standing to bring the claim. So on this record, I don't think the court could find the federal foreclosure bar to be applicable because there's nothing in the record that establishes standing for US Bank. Your Honors, if you don't have any additional questions, I'm happy to just rest on my papers, but certainly we would also argue that the property interest that's at issue doesn't fall within the federal foreclosure bar. Thank you.
Thank you. And we'll still give you a couple minutes on rebuttal.
Thank you.
Good afternoon. It may please the court. My name is Melissa Martinez, and I'm joined with my colleague Shauna Abner and trial counsel Brandy Howard. And together we represent the appellee U.S. Bank Trust as trustee for LSF9 Master Participation Trust. And for brevity, I'm going to refer to my client as U.S. Trust or U.S. Bank, if that's all right. This court has had a number of opportunities to address the DC Condominium Act in the last 10 years. But what differentiates this case from the other cases that this court has heard is that this case went to trial. This is not an appeal from a dismissal. It is not an appeal from the grant of summary judgment. We had a multi-day trial, a bench trial in front of Judge Rigsby, and we developed a full evidentiary record. And a lot of these cases that we've been talking about this afternoon have reversed and remanded these kinds of cases for the development of a factual record. And we have that here.
I mean, what does that have to do with the statute of limitations? What record evidence is relevant to the statute of limitations question?
It's not just with respect to the statute of limitations, Your Honor, and I want to clarify that what is important here is that we have brought claims for quiet title and declaratory judgment. The federal foreclosure bar and the statute of limitations argument that my colleague has made with respect to the federal foreclosure bar is just one argument within the rubric of quiet title. We also argued that we have a better claim to title under with respect to unconscionability and the interplay between the Condominium Act and section 42-401, which is the recordation statute.
Yeah, I'm still not following. All those claims are barred unless you can get in under the 15-year statute of limitations.
That's right.
A suit was filed after 6 years, so you can't make use of, nothing matters if we can't get past the statute of limitations issue. So maybe we should start there. Okay.
In fact, that is my first argument. My first argument is that the issues with respect to standing and statute of limitations with respect to the federal foreclosure bar are a red herring because that's not our claim. Our claim is for quiet title. And I heard Mr. Thomas make this distinction between reclaiming land and reclaiming a contract right. Now, I want to make sure that we're all on the same page here with respect to the facts. There was a condominium foreclosure sale in 2014 where TYROSHI purchased the property at a non-judicial foreclosure. In 2015, Wells Fargo, which is the prior servicer, initiated a judicial foreclosure proceeding because TYROSHI did not record its deed. They didn't know that the TYROSHI had purchased the property at a prior non-judicial foreclosure sale. And so during the judicial foreclosure proceeding, the substitute trustees found out that TYROSHI may have some sort of property interest, sent all of the notices relating to the foreclosure to TYROSHI.
Yeah, but didn't file suit. Didn't file suit for many years. I mean, so they've gotten notice at that point that TYROSHI has bought this at a foreclosure sale and, pursuant to our case law, thereby extinguished any prior liens because it's a super priority lien that was being foreclosed on by the condo association. So now TYROSHI's got it. Your clients have noticed that TYROSHI's got it and you don't file suit for many years, way past 3 years.
Now, I do want to clarify, Your Honor, what the trial court found after listening to all of the evidence is that U.S. Bank may have had notice that a non-judicial foreclosure sale may have happened, but it did not have actual or constructive notice that the property was actually sold at that sale. The judge credited the testimony of the substitute trustee who
Can
carried
you
on
tell
the
me,
judicial
can you tell me where you're
foreclosure
getting
sale.
that from the judge's order?
Yes, of course.
I mean, I would think notice, you have notice of a prior foreclosure sale would be enough to put you on inquiry notice to go find out who bought it and give you all the notice you need necessary for the statute of limitations to accrue. But you're telling me there's a finding that says otherwise?
That's right, Your Honor, and I'll wait for my colleague here to give me an appendix page. But what he found after listening to the substitute trustee, James Clark, who'd been doing foreclosures for 30 years, specifically said that so in non-judicial foreclosures, you record a notice of foreclosure. Many times, those never go to sale. They reinstate. Lots of things happens. That's at JA 1564. The judge credited that testimony. And so because TYROSHI did not record its deed until 2018, during the judicial foreclosure sale, we could have hashed all of this out. This issue with ownership, because TYROSHI got notices about the judicial foreclosure. They sent all of the
Yeah, but
notices.
why would they want to bring a suit? They already have it. They're under the law, that prior foreclosure purchase on a super priority lien extinguished all other liens. They've got it. You can do whatever you want, guys. You guys can go run around and trade it back and forth all you want, but we're the ones who have the priority here. And until you guys sue us, we're going to be quiet.
And in 2015, they did not know that because the TYROSHI deed was not recorded.
Yeah, but you did know about, on the day of the assessment of the foreclosure, Fannie Mae, from whom the LSF9 purchased the mortgage, they conducted an assessment of the property. The court found this. And the trial court found that, and the US Bank admitted because it was aware that Ms. Gaines had defaulted on her assessments. In other words, US Bank's predecessor in interest was aware that a foreclosure sale had taken place. And indeed, the association had recorded the notice of foreclosure, and an advertisement of sale had been circulated in the local newspaper. So to argue that US Bank was somehow not on at a minimum inquiry notice seems a bridge too far based on this trial record.
They might have been on inquiry notice, but that doesn't excuse the fact that that US Bank did try, or Wells Fargo at the time, tried to get TYROSHI into the judicial foreclosure, sent them all of the notices to the address that was on file with the DCRA. And Mr. Barrett Ware, who is the managing member of TYROSHI, testified that he knew that that judicial foreclosure was happening. He showed up
Yeah,
at the
what-
day of the sale and
But you
dumped them
didn't-
down and said,
but you didn't
"He's the
sue 'em.
owner."
I mean, why do they have to show up? They've got it. You guys want to say, set aside that foreclosure sale. It extinguished our interest in it. You're like, yeah, maybe you want them to come and bring the fight to you, but it seems like a mistake. As the law, you might not have known this at the time, but our law in this area has evolved quite a bit over the last decade. There's been some statutory amendments. But it later became clear that that 2014 foreclosure sale extinguished your interest, and you might have sought to bring them into your own foreclosure sale, but why would they have to do that?
Well, first of all, Your Honor, we don't concede that it extinguished our interest because they didn't record our deed. And an unrecorded deed, according to DC Code 42-401, is ineffective as to a creditor, which US Bank is. And the trial court specifically found the US Bank is a creditor. And so we have the judicial foreclosure happening. Judge Pan, when she was in the Superior Court, ratified that sale, and US Bank recorded its deed immediately. It wasn't until a year and a half later that TYROSHI recorded its own deed, a deed that doesn't say that they were taking the property subject to any deeds of trust, which differentiates it from a number of the cases that this court has handled, including New Penn and Flagstar, which did have that language in the deed.
I want to circle back to the statute of limitations. I'm still confounded as to how a suit essentially to quiet title is not time barred, because 301 and 308, they're really getting at possessory of lands. US Bank actually already possesses the land when it sues. So the idea that it's seeking to recover possession thereof seems inapplicable, because you're literally seeking something inherent in like an equitable court. You're looking to quiet title under our and what we announced in Ward v. Wells Fargo seems to be directly on point, that you're differentiating between quieting title and possessing land, and you have to flow within the two statutory limitations, the 3 and the 6 and the 15.
No,
How do you get around that?
Is, Your Honor, and it probably makes sense to bring the court back to how this case started in the first place. This case started as TYROSHI suing the condominium association, Jenkins Row, for wrongful eviction, because during that period of time,
Mine's a math
TYROSHI was the
question.
one.
Counsel, mine's a very simple math question. How do you get around the statutory bar of 3 vice 15 years, vice 6 years? You're over 6 years, you're over 3 years when you bring suit. How do you get past that?
Because the 15-year statute of limitations applies, and there are two cases that frankly, I don't think either party briefed this issue and did it justice. Nicklin versus Stonedale Unit Owners Association, which this court issued last year, that's a 307 A.3D 477, said that while the statute of limitations governs claims at law, the doctrine of laches may be a bar to to stale equitable claims. So when we're dealing with legal claims, specifically just a pure contract right, et cetera, there you deal with the statute of limitations. But where you deal with equitable issues, and you have plenty of case law from this court saying that quiet title is equitable in nature. Declaratory judgment absolutely is equitable in nature. There you deal, it's a laches issue, not a statute of limitations issue.
When has laches been argued in this case?
No, Your Honor. Well, we did raise it in the trial court.
Trial
as the
court's ruling is
defense
all about 15-year
citizens
statute of
to their
limitations.
Quiet title claim. I do also want to raise that in Johnson versus Fairfax Village Condominium, 641 A.2D 495, and it's on footnote 10. This court said in 1994 that the 3-year statute of limitations may well not be applicable to claims seeking equitable relief from a condominium foreclosure sale because laches applies to quiet title claims. The court also cited the 15-year statute of limitations.
So counsel, is that anywhere in the record below this theory that you're raising on appeal, which strikes me as for the first time, this theory of the doctrine of laches? Are you raising that for the first time on appeal?
No, Your Honor, we actually raised it as a defense because TYROSHI also brought a quiet title claim against US Bank. And so it's in the proposed findings of fact and conclusions of law in our response to TYROSHI's. There is a section on laches.
Can I just pull back for a second and see if I understand your position? In your view, is every claim to quiet title, by virtue of it being a claim to quiet title, also an action for the recovery of lands and thereby subject to a 15-year statute of limitations?
I don't know that I can make that broad statement. I believe in this case, it is because TYROSHI had possession of the property and in fact had tenants there and was collecting tenants, rent from the tenants at the property for over 4 years. And that's how this case actually began. And so when we're talking about recovering lands, we had a deed that we had filed with the recorder of deeds, but we didn't have access to the property because TYROSHI had people in there.
All right, let me try the similar hypothetical that I did with appellants. Let's say I sell my house to somebody. They've defrauded me in some way or another that I become aware of on, day one after I sell the house. They promised me some stuff. I didn't get that stuff. I want my house back. But I don't bring my suit within the 3-year statute of limitations applicable to fraud. I instead wait 12 years and then I sue them and say, I'm seeking to recover lands. Therefore, I'm within the 15-year statute of limitations. Do you think that's a timely suit?
I don't know that I've seen a case from this court or in fact in your federal counterpart addressing that particular issue. I do agree with your Honor's comments earlier that you look at what exactly is the nature of the claim. And here we brought a quiet title claim that relies not only on equitable principles, but also legal principles. We raised the issue of us being the first to record while we were a creditor, and therefore we have a safe harbor under the recordation statute. We also raised unconscionability. We also raised the federal foreclosure bar. So these are not single arguments that stand on their own, but the court considered them all together to determine that US Bank had a better title than TYROSHI did. And in fact, it was very significant to the court that we were the owner. We kept paying for property taxes, insurance, everything associated with this property.
The question is this fair to your client? The answer is definitely no. It would not be fair to, if they didn't record their deed, they let you guys sit there and pay taxes. That might be part of an unjust enrichment claim that survives. But I mean, the prior question and saying that this is about equity doesn't get you around it is that, and this is exactly how the trial court analyzed it, is you've got a statute of limitations problem. It's 3 or it's 15. The trial judge says it's 15 because this is an action for recovery of lands. That's kind of full stop. That's, I think he dedicates
That's
one or two sentences to it. As does Lancaster dedicate one or two sentences to it at a motion to dismiss stage. And the problem with that reasoning is that every case I see, including in every jurisdiction that is about the recovery of lands, is an ejectment action, that it's trying to get somebody off of your land with really no dispute that you're the one who owns it. It's not, we have some fight about a contract that we previously made. That's a contract claim. And it's not a fight about, did you wrongfully foreclose earlier or fail to record a deed? That's a tort claim, the wrongful foreclosure at least. And this just feels like that. It feels like your claim is, sometimes phrased this way, is a wrongful foreclosure claim, classic tort, 3 years. It's not an ejectment action. You need to get around their 2014 purchase to have any right to this land. And that requires you to set aside that foreclosure. And how on earth is that a 15-year? How is that an action for recovery of lands? It sounds like a classic tort to me.
No, Your Honor, it is for the recovery of land because US Bank purchased the property at the judicial foreclosure sale, got a deed that it recorded before TYROSHI. So it has a deed saying it's the owner of the
You
property.
purchased the
recorded
property from who? From Wells Fargo?
Yes, Your Honor.
Whose interest in the land had been extinguished by the 2014.
It became an REO property. It was not extinguished because this was a Fannie Mae property at the time. They had to check the box of getting consent from the FHFA, and they didn't do that. We're not raising a federal foreclosure bar as a claim by itself. It supports our claim for quiet title that we have a better claim title of this property that we didn't have access to because TYROSHI had renters in there paying rents. Unless the court has any other question, we'll rest on our briefs and ask the court to affirm the judgment of the trial court. Thank you.
Thank you. Mr. Thomas, we'll give you 3 minutes on rebuttal.
Thank you, Your Honor. Briefly, just on the federal foreclosure bar issue, US Bank in its briefing stated that it was not pursuing a claim under the federal foreclosure bar. I heard opposing counsel say that several times while she was up here. So we would argue that it's fairly clear the federal foreclosure bar is not being asserted in this case and was improperly relied upon. Next, I'd like to focus on this question about whether the unrecorded deed was ineffective against a creditor. I think that that argument is plainly untrue under the decision in Chase Plaza. The terms of DC Code 41, I believe it's 1403 or 1409, concerning the super priority lien is that upon the sale, 6 months, and then it extinguishes the remaining people who are of a lesser priority, which would be in this case, US Bank or US Bank's predecessor in interest. So essentially, at the date of the foreclosure sale, or certainly at closing, they were no longer a creditor. So whether there was recordation or not is somewhat irrelevant to the court's analysis. And then finally, I want to get at the laches claim because it's something that hasn't really been raised at all previously.
Is that right? Your opponent said it was raised below.
I don't recall it being argued in the trial record, and I want to be careful about what I'm representing to the court here. Certainly, I can't sitting here today, say it didn't appear in a pleading, but it certainly was not an issue that was directly addressed or meaningfully addressed in the trial, nor was it addressed at all in any of Judge Rigsby's rulings from the day he dismissed the condo association to the day he entered his amended judgment in this case. But be that as it may.
And it doesn't appear in the appellate anywhere.
That is also correct, Your Honor, but not having the benefit of the cases that my colleague cites to, I would just say that laches tends to look first to the statute of limitations as the appropriate period. So while it is an equitable doctrine, it wouldn't foreclose the application of a 3 years limitations period, which we all seem to agree is probably the most applicable limitations point. And then finally, Your Honors, on the possessory point, Your Honor, Judge Crowell, you pointed out that US Bank was in possession of the property, and it was sort of circular for them to be claiming that they're reclaiming lands that they already technically are in possession of. In fact, The condo association also at one point was in possession of the property. That was the genesis of the suit. My client sued for wrongful eviction, which this court found was the wrong claim to make in a per curiam decision. But the point being is that if reclamation of lands would have applied to anyone, it would have applied to the condo association. Certainly not my client, who never had possession of the property while this case was ongoing. We ask that this court reverse the judgment of the lower court. Thank you very much, Your Honors. Thank you.
Thank you. Thanks to both sides for your arguments today. The case will be submitted. The second case on the calendar is not scheduled till 3 p.m. So I want to make an inquiry. Mr. Green, do you have any information about whether the council is ready to go a little early?
Yes.
Okay, so, okay, great. Thank you. Second case on this afternoon's calendar is number 24 AA 511 Advisory Neighborhood Commission 2C versus DC Alcoholic Beverage and Cannabis Board. Whenever you're ready.
Your Honor, is counsel for the board here?
Okay,
So
Recess for.
it's just counsel for the intervener and I'm
Okay.
counsel for the petitioners.
okay, counsel for the board is not present yet, is that right? So why don't we take a recess and at least until 3, or if council shows up sooner, Mr. Green will let us know. Apologies for that. So, okay, thank you.
All right. Take a short recess. All right. This honorable court is back in session. Please be seated and come to order.
Okay, returning to number 24 AA 511 Advisory Neighborhood Commission 2C versus DC Alcoholic Beverage and Cannabis Board. I apologize for trying to starting to go on without some of the council here, but we're ready to go.
Good afternoon, Your Honors. Joseph Folio on behalf of the petitioners. May I please reserve 2 minutes of time for rebuttal? Unlike any other jurisdiction in the country, the District of Columbia allowed a medical cannabis retailer to be located next to a school without any buffer. To do so, the board relied on a since repealed part of the DC code to issue a license for the intervener DC Smoke to relocate from its pre-existing condition location at 508 H Street Northeast to 717 D Street Northwest, an area in the heart of Penn Quarter and with the highest concentration of young people in all of ANC 2C. This location is across the street from the Basis School at DC Charter Public and High School, around the corner from Templeton Academy, a private preparatory middle and high school, and a block away from KinderCare, which is a preschool and a daycare school. Before we turn to the merits of the board's decision, I'd like to address the jurisdictional issues raised by the court, the board, and the intervener. The court, the board, and the intervener have raised these jurisdictional issues. However, the court does have jurisdiction over both the petition filed by ANC 2C as well as the petition filed by Thomas Lee in his individual capacity. With regard to ANC 2C, the 2022 Medical Cannabis Act, by operation of limiting the right to protest a licensing application solely to neighborhood commissions, implicitly repealed the otherwise broad but general prohibition.
Counsel, I have to interrupt. Why would we need to even look at an implicit revocation when the statute in DC Law 1309 G is explicit? You don't have standing as the ANC. It explicitly says you lack the power to initiate a legal action in the courts of the District of Columbia or in the federal courts, period, full stop. How do you get around that? That hasn't been repealed. That's still the body of law. And you argue in your papers that it would lead to an absurd result. But in Purdue, we've often said it may be inefficient, but it doesn't necessarily make it irreconcilable. So how do you have standing to even bring this suit on behalf of the ANC when the statute that we must apply is quite clear? You don't have standing. You don't lack the authority to even bring this lawsuit.
Your Honor, the petitioners acknowledge that an implicit repeal is disfavored in the law. However, it nonetheless is a remedy available to the court, and we believe one that is appropriate here. The statute Your Honor pointed to is clear, but it is a general prohibition on ANCs. And the court must contrast that with the 2022 Amendment Act, which among other things, limited the right to protest a licensing application to ANCs. They are the only party able to protest a licensing application, which means they're the
No,
only.
they aren't. A citizen that lives in ANC can file that lawsuit. That's explicitly what's brought in mind by the statute. If, just like in the liquor license, just like in Purdue, if the ANC brings the lawsuit, the commissioner brings the lawsuit, they don't have standing. And perhaps the commissioner might, you might argue, but certainly the ANC doesn't as by operation of law. So someone who lives in ANC 2C, dissatisfied by the board's result, could bring the PFR. They didn't. There are plenty of people. All the people who live in ANC 2C could have brought this lawsuit. In fact, we have found repeatedly that they are empowered to bring, not only bring on behalf of themselves, they can bring it on behalf of all the rights that may exist within the ANC. They get to adjudicate the broader rights of the ANC as an individual living in that ANC. So how do you address that? There are people who could have brought this lawsuit. They just didn't.
Your Honor, the difference is the distinction between the right to protest and the right to file a lawsuit challenging the decision of the agency. The right to protest in this instance was confined to the ANC. That means the ANC was the only party that was able to create the record below. So while you're right that in theory the individuals could bring a lawsuit challenging the decision of the protest hearing, they're not the party responsible for creating the record, and this creates incongruities. It's unlike any other regime in which typically courts want to see the party that made the record below pursue the record on appeal.
But that's why I mentioned Purdue, because that's pretty much what we did back in 2013, right? And that involves the Alcohol Beverage Control Board, where we recognize that individuals before the PFR, before the court as valid, even though standing alone, he could not have petitioned before the board. We've already said that you could do that in Purdue. We've already recognized, we've already implicitly endorsed that very statutory scheme where they're not irreconcilable. They're certainly inefficient, but it doesn't mean that they're irreconcilable. They can't be read congruently. How do you get around our decision in Purdue?
So respectfully, that was a different decision. In Purdue, there was congruity. So the issue there was that the protest right was confined to a group of 5 people, among others. The ANC could protest, neighborhood associations could protest. The issue in Purdue was whether once a group of 5 people protest, whether only one person of that group of 5 can bring an appeal. So throughout both the protest and the appeal to the petition for review in this court, there were the same parties. Here, that wouldn't happen. And this presents issues. And the main one that we flagged in our papers is the jurisdictional issues. So you're right that while an individual citizen may have the right to vindicate the rights of an ANC, for example, whether or not something was given great weight, they may not have the right to vindicate all the arguments raised by a neighborhood commission. For example, if the issue is about whether or not the schools are affected and students, if there's an individual that wanted to raise those issues, they'd have to be a parent or otherwise be associated with the school. So you just see this incongruity between all of the weight for raising the arguments and making the record rests on the ANC, and they are not able to pursue an appeal.
Yeah, I mean, I guess I share Judge Kroll's reaction, which I can agree that it's odd. It seems like something that the DC Council might want to reconsider, having only one entity being able to file the protest and that entity also being precluded from filing its appeal. Does not strike me as absurd. It strikes me as probably a bad idea. But there's nothing wrong. I mean, as Commissioner Lee has sought to take up this mantle, a bit late. In a typical case, so if the ANC can't bring the appeal, one of its commissioners can if they want to. And I take your point that, well, maybe if they want to bring claims that are on behalf of students who need to be a parent, and that's just, okay, so it needs to be a parent, go find one of them. Those all strike me as, perfectly fine points for why the DC Council shouldn't have done this, and maybe why when they passed the statute allowing only the ANC to file a protest, they probably did not have at the front of mind the fact that they can't file an appeal. And so maybe they should reconsider that. But to get to an implicit repeal, my rough sense of the law is they just kind of need to be totally inconsistent in order for the previous law to be implicitly repealed. And it's definitely, I mean, I don't see an inconsistency. I see an oddity.
Yeah, sure. Again, we recognize that implicit repeal is disfavored. It is an uphill battle for the petitioner in this instance. However, I think in this unique circumstance, it does create this unique situation, which I'll note is unique in the sense that the law has since changed. So what we're focused on is a type of license that is no longer being issued. And the DC Council has since changed the law and now does allow, more like the alcohol regime, groups of individuals to bring suit. So if we are advocating for an implicit repeal, it would be a very narrow decision and frankly would probably only apply to this case. However, this is not the only avenue we have to have jurisdiction before the court. In the alternative, we argue that Mr. Thomas Lee in his individual capacity also has standing, and this court has jurisdiction to hear the petition for review. We think the easiest path for the court to make this decision is to allow us, as we did in our response to the court show cause order, to amend the petition to add Mr. Lee as a petitioner's individual capacity. That would work no harm, prejudice, or injustice to the board or to the intervener, who are aware on day one, on May 31st, that there was a challenge to the decision of the board. And also it would be fair. This court's jurisprudence is rich with several cases that have made clear the desirability of judicial review of agency action. And that desire is.
But not in the absence of jurisdiction to even hear the claim in the first place. Why isn't Rule 15A3, big A, jurisdictional? I mean, it is not a claims processing rule. It is the person bringing the lawsuit. It is replacing someone who lacks statutory authority to even bring the lawsuit with someone who may be able to bring the lawsuit but didn't file it. And so why would we not just simply, it's jurisdictional in and of itself. So I don't see, and thinking like, don't tear it down is particularly on point in this area, is we're replacing someone, an entity that could not have brought the lawsuit in its place. That is in and of itself a jurisdictional basis for the lawsuit to begin with, to initiate it ab initio. There's no, the person who brought the lawsuit didn't have the standing to bring the lawsuit in the first place. And then as the lawsuit has moved forward, you want to replace the person who could have brought the lawsuit with somebody who may have been able to bring the lawsuit. Why isn't that jurisdictional ab initio?
So, Your Honor, this court's decision in Don't Tear It Down is distinct because the issue there was substitution. We think the better path for this court to consider is amendment. And this court has found, and under not only this court's jurisprudence, but other courts' jurisprudence, that Rule 15, the rule to amend, which we think is the easier path that the court should follow, is non-jurisdictional.
And sorry, just as a starting point, explain to me what you think the difference between those two things is in this context.
Substitution and amendment?
Yes.
Yep. So in the Don't Tear It Down case, the substitution motion was to substitute the ANC in its official capacity for someone in their individual capacity. And the issue there turned on a variety of things, but although it did not allow the commissioner in his individual capacity to move forward, it did so in the context of recognizing there were several other petitioners who had filed a petition for review and were able to carry forward the suit nonetheless.
Your adversary says, read that footnote. It has two independent bases for why it's not allowed, and it wasn't dependent on other people being able to carry it forward. I tend to agree with that reading of the footnote. Do you have a response to it?
Yeah, the footnote is decidedly unclear. It does not make it two independent tests. It mentions two things. And the fact that it's mentioned one thing, again, is important context to recognize that the court acknowledged, again, the desirability of judicial review and that the case would be moving forward regardless. But here, that's not the relief we're primarily asking for. The relief we're asking for is an amendment of the petition in the first instance, right, that would allow Mr. Lee, the same person who is standing before this court on May 31st, filing a petition for review. So again, the congruity is there here, right? He's literally just putting on a different hat.
But how
So-
do you read the language of Rule 15? The petition for review must be filed within 30 days after notice and find that that's not mandatory.
So two arguments, Your Honor. First, the amendment issue is a different issue, right? So we're just moving to amend and there's no time limit violation. Our second argument is this is the later filed petition by Mr. Lee. So under this court's decision in Mathis, which analyzed the 30-day filing deadline, it found that it was non-jurisdictional, which means that that is a deadline that this court can equitably toll. And we think equitable tolling is appropriate here given the circumstances, especially given the novel and complex legal regime and all the emergency regulations that were passed during COVID to try and make sense of what was going on.
But Mathis is an A2, Rule 15A2, non-jurisdictional. This isn't a jurisdictional. This is under A3A. This is not that the Mathis decision, because it was about a deadline imposed under 15A2. This is a jurisdictional. It's the second sentence. If you look at the APA, Title 2510A, it talks about the first line. It doesn't mention timeliness and the fourth sentence, which requires PFRs to be filed within such time as prescribed by this court. Those didn't have jurisdictional import. That was what we were talking about in Mathis. By contrast here, this relates directly to jurisdiction. The first sentence of 2510A describes the kind of person authorized to file. It talks about the person authorized to file. And under 310G, it explicitly says an ANC can't be that kind of person. And then it goes forward to say that it requires a petitioner to name the agency as a respondent in a PFR was non-jurisdictional because the relevant authorizing statute in the case made no mention of that requirement. Why isn't that applicable here? It's jurisdictional. It's not the same body of law. It's a time processing versus a jurisdictional issue here under 15A3.
So just to separate the arguments, so two separate arguments on the amendment issue is non-jurisdictional, but with regard to the 30-day filing, that also is non-jurisdictional. So it's non-jurisdictional, this court found in Mathis, because the 30-day deadline is not something imposed by statute, which is the first part of the analysis, right? And the second part of the analysis is whether or not there was any sort of clear intent to make sure this was a mandatory exclusion. And in Mathis, this court said it was not, which means the court would allow equitable tolling. So again, we think amendment is the easiest path. However, we think a comparable easy path too is to allow Mr. Lee late filed petition to proceed. We do think equitable tolling is more than appropriate in this circumstance.
Can
As
I
I noted, again, everyone was trying to make sense of this novel and complex legal regime. If you look at the board's decision, right? So again, I know we talked about this earlier, but the only person that could initiate the protest was the ANC. So the ANC initiates its protest, it gets a decision. And what does it say at the end of the decision? It says, if you have any concerns about the decision, file a petition for review with the court, right? So this was just a novel time, a new regime, more than equitably told. They randomly thought that they were able to petition because they were the only one able to protest. And here, the result that we're asking, the relief that we're asking for is allowing one way or the other, Mr. Lee to petition in his individual capacity. He's been here since day one. He would just be putting on a different hat. And this achieves all the court's stated goals of the desirability of the judicial review of agency action.
Can I ask who is doing the amending of the petition under your view?
So it would be the ANC.
If the ANC does not have standing before this court, why would they have standing to file an amendment to their petition? I mean, usually, the way I think about standing is generally, you're not even here. If somebody's not properly before us, they can't take any activity before this court. So amendment is out, if I'm right about that, but I'm inviting you to tell me why I'm wrong about that.
So not necessarily, Your Honor. So in this court's decision in OPC against the DC Water and Sewer Authority, it recognized without deciding the ability to amend, even if the first party wasn't appropriately there. And that was the issue of whether OPC, an advocacy group, could file on behalf of the individuals. It dismissed the case on other grounds, but this court explicitly left open the issue of whether or not that would appropriate given the ends of justice.
Yeah, I was on that panel. I remember we had some disagreements about it. I won't tell you which side I was on.
Again, it's not an easy issue, Your Honor, but this is why we look to the other court's decisions when they talk about the general principles of the desirability of judicial review, right? I mean, like taking a step back, all things equal, Mr. Lee was there in day one, right? Everyone in the world knew that there was going to be a legal challenge and they had serious concern. And all that we're asking is that Mr. Lee be able to stand here and advance the challenge. The other case I'll point you to, which we said in our reply brief, is a DDC federal court decision, Achievers against Karolakis. That decision was similar and I think provides this court some additional guidance and comfort here. In that case, there was a governmental entity that filed a lawsuit that wasn't a recognized government and therefore it did not have jurisdiction and standing because of operations of foreign affairs law. During the course of litigation, I think even after appeal, that government got assumed into the legitimate government and therefore did have standing. And that case was allowed to amend and the court addressed the issue and said it's okay to amend, especially if you're addressing a capacity to sue issue. So we think that case is telling and helpful here. There are no other issues in the jurisdiction. I see that my time has expired. I have not addressed the merits issues, but I defer to the court.
Let's hear them out.
Please quickly address the merits if you'd like to.
So Your Honor, set forth in our papers, we have two reasons why we're asking the court to address the decision of the board. The first is the preemption issue. And our position is that the board's decision is contrary to law and therefore must be set aside because it is preempted by federal law, specifically the drug Drug-Free School Zone Act. The second set of arguments are record review arguments. And for three independent reasons, we've made arguments about errors that the board committed below. And each of those are independent reasons why the court would set aside and remand for further proceedings. So the first, the preemption issue, the decision would be vacated and set aside because it would be contrary to law. The second set of arguments, those three, the court would be remanding for further proceedings. On the preemption issue, the issue boils down to this. So for a brief period of time, the DC government had an exception to its law about the buffer zone between cannabis facilities and schools. And that law, as I noted in the opening, was unlike any other law in the country. So Drug-Free School Zone Act, the federal law says you must be 1,000 feet away when distributing controlled substances. DC has that on the books too. However, in the course of implementing medical marijuana, what the DC government had reduced that distance to 300 feet. However, there's a provision, a narrow provision that said in certain circumstances that buffer zone has to be 0 feet. We are asking for a very narrow preemption finding here. All this court needs to look at is not just the Drug-Free School Zone Act, but specifically the issue of, is there a buffer? The court doesn't need to decide, does it need to be 1,000 feet, 300 feet what it was, or 400 feet what it is today. It just needs to decide, is a buffer appropriate or no buffer? And this exception, which again has since been repealed, this was the exception the board relied upon to grant the license at issue. And that exception said no buffer. There is no starker contrast between federal law, which says there must be a buffer, and the state law provision we're challenging here, which says
The
no.
federal law actually about the 1,000 feet, what is it actually requiring be 1,000 feet away?
The distribution of controlled substances.
Like a person selling drugs?
Correct.
But if if it's 1,000 feet away, then it's legal?
No, Your Honor.
Okay, I mean, it just seems like it's apples and oranges. It's a completely different kind of statute.
I'm sorry, Your Honor, different compared to?
I mean, it's not about a business selling medical cannabis. Right? I mean, it's a criminal statute.
Yes, Your Honor, that's correct. And obviously there is ongoing discussions between the federal government and the states exactly about how controlled substances like this should be dealt with. But regardless, the federal government and all these states have laws that say if you're going to engage in this conduct, whether we think it's totally illegal or legal in certain circumstances, there must be a buffer between that conduct and schools.
But in those cases, I mean, 21 USC 860, it's designed to get at and prevent the sale of drugs within schools and in keep neighborhoods, kind of the old drug-free zone idea behind it. And nothing in the DF, I always forget the acronym, the DFSZA, nothing prohibits the federal government from coming in and arresting everybody in DC smoke, charging them under 860. Nothing prevents, they're not incongruent, they can still do it. It's just whether they will. In since 2015, the Department of Justice has declined to be funded with the congressional rider of enforcing that law. That's kind of how the operating fiction we've collectively operated under for the last decade. And so this idea, how can it be, if the federal government's not going to enforce a federal right, and it's not enforcing that federal right, how can we say that it's actually being preempted? I mean, if they're not going to enforce that federal law, and they are not, then how do we agree with you that it's even preempted in the first place? Because the idea, and forgive me, the idea of preemption in federal law is that the federal government is enforcing or involved in some type of enforcement law that preempts the state doctrine or the state law in that particular area. The law exists on the books, but it's not being enforced. So how do we say it's preempted? The whole idea behind preemption starts with that idea, that concept.
So as an initial matter, it doesn't matter, right? It doesn't matter what the government's choosing to do or not. The issue is there a conflict between the state law and the federal law? As a practical matter, I'll note to you that prior to 2015, 2014, the federal government was in fact actively enforcing not medical marijuana, but medical marijuana that was being being distributed close to schools. And in fact, although the waiver was in existence, and the waiver of course doesn't repeal anything, there was a recent change in the law, and the most recent rider addressed this issue and in fact encouraged, it was the 2024 appropriations rider, and that rider no longer precludes the Department of Justice from enforcing the Drug-Free School Zone Act, and it made specific reference to 860. So effectively, it's giving the green light to the Department of Justice to engage in the behavior that it was engaging in 2015, which is enforcing these laws. And to your Honor's prior point, it doesn't have to create an impossibility, necessarily an impossibility or totally prevent something. You know, the Supreme Court addressed this in Crosby when it said the conflict is imminent when two separate remedies are brought to bear on the same type of activity. And as the court looked at in Murphy, this is the Supreme Court's decision citing our papers, any state law that confers rights to do something that federal law otherwise prohibits creates a conflict. Because what that does is it provides people with freedom to engage in the conduct. It provides them with a right of authority to act, and it effectively empowers them. And that is more than sufficient under the
I'm
preemption
sorry,
law.
what is Murphy? Is that the case you just cited?
The Murphy case,
No,
correct.
just want to take a look. Thanks.
And that is more than sufficient grounds for this court to find that there's preemption.
Can I just ask, so let's say, the federal government outlaws, I don't know, Toyotas. And the district doesn't outlaw Toyotas. But they do generally permit people to register their automobiles without regard to whether or not it's a Toyota. Do you think that registration scheme for not making an exception for Toyotas is preempted by federal law? Because I would think, well, no, the federal government can come in and enforce their ban on Toyotas whenever they want. But the district can't be commandeered into doing it. You can't make them do it. If the district doesn't want to ban Toyotas, then they can still regulate it in the way they regulate everything else. It just doesn't sound to me like a preemption problem at all, which is why I was interested in your Murphy, because I want to go look at that. But what if the district just didn't regulate marijuana at all? Would you still have your preemption point that says sell it wherever you want, guys? We have no laws on the books about marijuana. We're going to leave that to the feds. You would say that inaction is preempted, or what's your reaction to that?
I think if there was no law on the books, that would not be preemption, right?
So
Because
by virtue of regulating it, somewhat.
by authorizing.
Well, but by having no law in the books about it is kind of like authorizing too, right? Like we don't prohibit you. Sounds a lot like authorizing to me. But by virtue of regulating something a bit, you need to regulate it as much as the federal government. I mean, it just sounds like a very novel theory of preemption. It would be odd. So if they just got out of the game of regulating marijuana entirely and let dispensaries, let many bloom wherever they want, with no restrictions, your preemption argument is gone. But because they regulate it and you don't like the nature of the regulations, then preemption springs into place. And that seems, quizzical to me.
But that's exactly why preemption law exists. I think Murphy actually includes a discussion about what you were discussing, whether or not if the state doing nothing itself was a violation. And the answer is no, right? It's the state taking affirmative action, and here by passing the law authorizing the placement of a dispensary within the buffer zone close to schools that creates the conflict, right? It confers rights where rights otherwise didn't exist. It's conferring a right in one instance where the federal government said, you don't have that right. We've outlawed this. And that's the preemption conflict. This is not a scenario like the one you were talking about, which was regulating a little bit versus like regulating a lot. This is a simple, can we do it here or can we not do it there? It's a location issue. Your Honor, I know I far exceeded my time. I'm happy to answer any other additional questions or defer for the
We'll
rebuttal.
still give you some extra time on rebuttal. Thank you. Can I ask whether you'll be handling the entire argument or will you be splitting time?
We'll split the time. So we'll take 10 minutes and then allocate 5 minutes for intervener.
Thank you.
Good afternoon, Your Honors, and may it please the court, TYROSHI on behalf of the District of Columbia Alcoholic Beverage and Cannabis Board. This court should dismiss the ANC's petition for review for lack of jurisdiction, and it should dismiss Mr. Lee's petition for review as untimely. And with respect to the ANC's petition for review, as this court acknowledged, the district's law has been clear for almost 50 years that ANCs do not have the capacity or standing to petition for review of an agency action in this court. Nothing in the text or the legislative history of the Medical Cannabis Amendment Act changes that or indicates any sort of intention by the council to expand the role and the litigation authority of ANC.
It is kind of weird, you have to admit, to require one body to do the protesting and someone else to do the appealing of that decision. Do you think that's what the council intended?
I think that the council knows what the limits of ANC authority are. And you're right, Your Honor, it is a little weird, but the ability to protest at all is something that the council created. So with the Clarification Act, which is the subsequent legislation since this petition, the council took away the ability to protest other types of medical cannabis licenses, such as cultivation licenses or internet retailer licenses. And so the idea that, it created a limited type of protest for a certain type of license. And it makes good sense to allow the ANC to protest, right? The ANC is an efficient way of collecting and communicating the views of the neighborhood to the agency. But the council did not then go on and change the legal authority of the ANC to appear before this court. And so that's just a decision by the council to.
Yeah, I mean, it definitely makes good sense to let the ANC protest.
Right.
It doesn't make a whole lot of sense to only let the ANC protest if the ANC can't then initiate an appeal of that protest. I'm with you in a limited sense that I don't think that strikes me as an irreconcilable conflict in the law. Can you just explain to me, do you understand the origins of the statutory prohibition? I mean, I can read the text and what it says, but why can't the ANC initiate suits in the district's courts? Do you know what animated that?
I do not know what animated that. I believe it's just because, at least in the COP decision, the court discussed the ANC's advisory role and the fact that they didn't have their own enforcement authority. But I don't know any deeper than that. But Your Honor, I know that so during this limited time period, the ANC was the only person who was legally allowed to protest. Now, of course, that standing has been expanded to other petitioners going forward for future licenses. But it's not that unusual for the ANC to be the only person who happens to protest. And this happens in, BCA cases, it happens in other beverage cases. And so the idea that just the fact that the ANC was the only person who appeared before a board would then enable them to litigate before this court, there's no connection between those two concepts.
No, I don't recall an argument like this, so maybe this is an unfair question, but are you aware, and I'm trying to pull it up now, but in the order granting the license, was there sort of any indication to the ANC, you can file a petition for review, that kind of boilerplate language that tends to follow orders? I'm kind of just curious if they kind of got lulled into bringing this appeal. I'm not sure that would matter if it's jurisdictional, but do you have any idea?
There's no argument that somehow misled.
I know that. No, there's no argument. I'm just wondering if it happened.
So that would be forfeited. And also, that says, the parties have an ability to appeal, but that's the boilerplate language that appeals in any case, right? That would appear in the alcohol cases as well. And this has been the law in the district for 50 years. And I think as an elected official, an ANC has a responsibility to understand the limits of their power.
But if the board tells the litigating party, you have a right to appeal, and then they proceed under what you tell them as the board, and their argument at this point is inequity, essentially. It's saying that it's unfair, and that in many ways, and that we should allow them to at least amend so that Commissioner Lee could. Why doesn't that kind of lend credence to that argument that it's perhaps a little unfair because you didn't tell them, you told them perhaps falsely, that they had a right to appeal when they really didn't? And why doesn't that kind of balance that we should use the trial, that we should send it back and allow it to go forward and amend?
There was nothing telling Mr. Lee that he could not appeal in his individual capacity. The board's order saying the parties can appeal is general boilerplate language, and any party that appears before this court needs to have standing. So that also includes, injury in fact, causation, redressability. And there have been cases where parties were found to have standing before the board, but don't have judicial standing to appear before this court. And the fact that, the boilerplate language says that parties may generally appeal to this court doesn't create any sort of right to appeal. And it doesn't create any sort of, and there's no allegation here,
Is that
any sort of
what the
confusion.
language is? Does it use the word generally or kind of a qualification like that?
I believe it says a party can appeal or may appeal. But again, there's no claim here that Mr. Lee relied on that boilerplate language as the basis for his confusion. Or in fact that as the basis for his confusion. And so because the ANC lacks standing, as this court acknowledged, this court lacks jurisdiction. And the ANC cannot create jurisdiction by moving to amend, but it doesn't have standing to appear here before this court at all, or capacity to litigate. And we don't perceive a difference in this sort of case between substitution and amendment. And Rule 43 is the rule that governs substitution. And this court in Don't Tear It Down made it very clear that you cannot substitute for a party that lacks standing to bring an appeal. So we don't believe that there's any authority for allowing a party to circumvent that prohibition by characterizing the request as an amendment. There's also no authority cited for allowing a party to circumvent Rule 15's timing requirement by characterizing something as an amendment. And the ANC cites to Archives, which is a trial court decision that was analyzing the Civil Rule of Procedure 15C. So at the trial level, the rules of procedure allow relation back in certain circumstances. The appellate rules of procedure do not have anything like that, and there's no authority for the court having jurisdiction to amend a complaint when it doesn't have jurisdiction over the petition for review. And as this court recognized, having a party actually petition for review, that is a jurisdictional prerequisite, right? The court can only hear a case if a party brings a petition for review of a final agency order issued in a contested case. And that's when jurisdiction attaches. And here, no jurisdiction attached within the time that is provided by Rule 15 for perfecting the appeal. And that leaves us with Mr. Lee's petition. So there's no argument here that there's any sort of jurisdictional problem with Mr. Lee's petition, but it is untimely because it was filed over a month after Rule 15's time deadline. And that rule is a mandatory claim processing rule. It's not jurisdictional, and that means it can be forfeited or waived. But when another party objects, it is not subject to equitable tolling. And I think that the Supreme Court's decision in Nutraceutical is exactly on point. I would direct the court to that, where the Supreme Court analyzed a virtually identical language in the Federal Appellate Rule 26B, which prohibits the court from extending the time. And in that case, then it listed the exceptions. And in that case, it was extending the time to seek permission to review a denial of class certification. Here, the language of our Rule 26B is framed in the same fashion, and it prohibits a court from extending the deadline to petition for review. And because the clear text of the rules demonstrate a clear intent to prohibit equitable tolling is not available. Let's see. And even if it was available, we discussed a little bit earlier, there are no grounds here for equitable tolling. That requires extraordinary circumstances, and there are no such circumstances here because as someone who is an ANC, who is a legal representative, Mr. Lee is in charge with knowing what the limits of his power are. And again, there was no actual claim that he had been actively misled by the board. Very briefly on the merits, Your Honors. With respect to preemption. So the Supreme Court has emphasized that an argument for preemption is especially weak in cases where Congress has indicated an awareness of some tension with state laws and has nevertheless decided to tolerate that tension. Here, 39 states and the District of Columbia have authorized legal cannabis use, and Congress has not acted to clamp down on that. In fact, it has specifically prohibited the Department of Justice from prosecuting those who are in compliance with states' medical cannabis regulations. Petitioners point out to a Senate report, which was attached to a bill introduced for fiscal year 2025. That bill was never enacted. It has since expired. And the current law, the current appropriations rider is the rider that we cited in our brief for the year, fiscal year 2024, which is still in effect as a result of the continuing resolutions. And so there has been no change in terms of what the Department of Justice is allowed to prosecute. And then on a final note, just touching the merits, but petitioner refers to this exclusion in commercial zones as having been since repealed. And it's true that going forward, new licensees or applicants for licensees will not be able to locate within 400 feet of a school. But in enacting that change, the council specifically considered whether or not to grandfather in establishments that had applied during this 90-day on-ramping period for unlicensed establishments to transition to licensed medical cannabis establishments. And you can see in the committee report, it specifically discussed Basis Charter School. And this,
But it didn't discuss kinder care. It didn't discuss that the kids go out to the Navy, in front of the Navy Memorial and they have lunch out there. It doesn't discuss those explicit reasons. And you're required to. The language is explicitly reference each issue. And you didn't talk about the kinder care. You talked about Templeton Academy. You talked about Basis, but you didn't talk about pre-K that's right there. And you didn't talk about the fact that the children have lunch outside of that area in and around directly on the streets where individuals are coming in to buy an illegal substance or perhaps get high and wander down the streets. That's part of that concern. And none of that is explicitly addressed by the board as it relates to kinder care or the outside area.
yeah,
How do you explain that?
Yeah, I will get to that. And I was referring to the committee report for the council. So like when the council expanded the buffer zone and removed this exception for commercial zones, it considered this particular retailer, and it specifically discussed Basis School. So it was aware that under its previous regulations,
Did it discuss kinder care? Did it discuss Templeton Academy? Did it discuss the other schools?
no, but it discussed that a retailer had been in proximities, that parents had concerns. It discussed the social science research, and it found that it was not clear at all that mere proximity created a harm. And it decided not to require to grandfather in those existing establishments and not to require them to find a new location. And so then when the board looked at the factors, right, the relevant legal factors, one of them, you're right, is proximity to schools and the effect on the operation of schools. But the regulations also make clear that the board must consider those factors in relation to the grounds for protest. So those are peace, order, quiet, vehicular and pedestrian safety, and property values. If the board was able to just consider mere proximity just by itself without thinking about like the other harms, right, that would
My
allow.
question's not about that. My question is about it. The words in the statute are explicitly referenced, and it didn't explicitly reference kinder care. It didn't explicitly reference the fact that the kids are having lunch outside of that. The Basis kids are going out. The Templeton Academy kids are going out and having lunch in that. Under the statute, it's required to explicitly reference it.
So this.
How is that? How is how is that record revealed that they had substantial evidence? Sufficient
So
substantial
the relevant statute here, Your Honor, is 7/1671/06A, which is the one that deals with unlicensed establishments. That does not have any requirement in the statutory text to consider proximity to school or effector school at all. The only grounds for protest that the statute provides, which is under subsection I, are the ones that I mentioned earlier. So peace, quiet, the safety, traffic of pedestrians, and property values. Then the board implemented regulations, and in its own regulations, it said, we'll consider proximity to schools and operations of schools as they affect those grounds for protest. And that's exactly what the board did in this order. It mentioned Temple and Basis, right? It did not mention kinder care, but it considered the measures that DC Smoke had taken in order to alleviate any potential concerns. So it frosted all of its windows. It has a very large space and will not utilize an outside line. So in fact, like, people would have to go inside where there would be someone checking IDs, checking their registration to make sure that they are a registered medical cannabis patient. And then only then would they be buzzed in to go to a back room where they would purchase cannabis, medical cannabis product on an iPad, receive that, and then leave because they don't have an endorsement to consume on the premises. They discussed,
Did they consider the armed guards that are stationed outside of that business? Because as I read the record, they're going to have armed guards as children are walking past the armed guards where people are going in and out to buy these illegal substances, at least.
So there was no testimony about whether the guards would be armed or not, Your Honor. Either way.
That's what I'm asking.
Yeah, that's not in the record whether the guards would be armed. There would be security guards that would maintain the safety of the premises, make sure no one is loitering. There'd be cameras. And at this point, right, there's no facts and the evidence to show that there's any reason to believe that these harms would in fact manifest and that they're anything but speculative. Because the DC Smoke had put in all of these security measures. And of course, they're a regulated entity, Your Honors. If these problems come up, nothing about approving their license prohibits the board from cracking down and making sure that they comply with the regulation.
How would that crackdown look? You can walk outside of this courthouse and within just several blocks, there are innumerable illegal, non-licensed marijuana and drug dealers. They're in buildings, you see them, and they're patently not licensed. You can literally walk outside of the courthouse. Who's gonna crack that down? Who's doing
And
that?
the ABC board is entitled to shut those down, and it is doing so. So you can see like every day there are more and more of those unlicensed establishments that are closed and padlocked by the Alcoholic Beverage and Cannabis Administration, now that they have the authority to do that. And that was part of the legislation here. So part of it was that we increased the authority of the board and the administration to close those establishments, to padlock them, to make sure that those who are not licensed could not operate in the district, and then provided an avenue for legal medical cannabis use under highly regulated circumstances. And those also include things like, prohibiting large signs, prohibiting anything that is like attractive to children. Those are all part of the regulations and all part of the things that the Alcoholic Beverage and Cannabis Administration ensures when it regulates one of these entities. Your Honors, if there are no further questions, we ask that you dismiss the petitions for review, and in the alternative, that you affirm the decision of the board.
Thank you very much.
Good afternoon. My name is Meredith Kidder, and my co-counsel John McGowan and I represent the intervener in this matter, UND Necessities LLC, trading as DC Smoke. The owner of DC Smoke, Tommy Monconsalvo, is also here with us in the gallery. I concur with all of the government's points, and with respect to the issues of standing, preemption, and the application of the Federal and District of Columbia Drug-Free School Zone Acts, I will rely on our papers. I urge this court to affirm the board's decision to allow DC Smoke to operate as a licensed medical cannabis retailer at 717 D Street Northwest. The board's decision is consistent with the law and is supported by both substantial evidence in the record and common sense. The board is the entity responsible for the promulgation and administration of the district's medical cannabis laws. As such, the board's interpretation of those laws must be afforded considerable deference, even where, as petitioner suggests, an alternative interpretation is possible. And it is appropriate here for this court to defer to the board's decision. Petitioners argue that the board's decision is arbitrary and capricious, and the matter should be remanded for 3 reasons. The board failed to consider DC Smoke's proximity to schools in its analysis of the appropriateness criteria. The board failed to rationally connect the evidence in the record to its legal conclusions, and the board failed to give great weight to the petitioner's concerns. Petitioners argued that the board's appropriateness analysis is legally inadequate because the board made perfunctory references to DC Smoke's proximity to 3 schools and also failed to consider petitioner's mere sight argument. Namely, that students at these schools will be harmed by the mere sight of a medical cannabis retailer and medical cannabis patients. But in fact, the board did consider petitioner's mere sight argument in the context of the appropriateness criteria, and it explicitly rejected it. The board found that as a matter of law, the appropriateness criteria does not include any harms stemming from the mere sight of a cannabis facility. The board also recognized that petitioner's mere sight argument is actually a policy argument that should be addressed by the legislature and not the board. Now petitioners ask this court to equate proximity with harm and to legislate by judicial fiat. This is worth repeating. The gravamen of petitioner's argument is that students at schools in downtown Washington, D.C., the majority of which are high school age students, will be harmed by merely seeing a licensed medical cannabis retailer and medical cannabis patients on their way to and from school. Petitioner's argument.
Counsel,
Yes.
Are the signs different? You use the word licensed. Does it differentiate? Is there some emblem that demonstrates that this is outside the sign? I referenced earlier some of the ones that we literally can walk outside the courthouse and see that they're patently not licensed. Does it differentiate? Or when the kid's walking by, do they see a sign? There's an emblem that says licensed by the District of Columbia. Is that clearly situated outside? How do they differentiate?
Unlike with alcohol establishments, medical cannabis establishments are not required to print their ABCA license number as of now. They're not required to print that and have that.
Wouldn't that be a good idea?
That perhaps that would. I would certainly urge Your Honor to make that suggestion to the board. Yes, I think that would be something that would be helpful.
But it's not
But
required.
they are required once you're inside of the medical cannabis facility to have their license, their medical cannabis license, their business license, their certificate of occupancy, all clearly posted.
Thank you.
You're welcome. Petitioner's mere site argument and their concerns about related harms are purely speculative. And while it may be reasonable for parents to have concerns about their child's school environment and potential negative influences, it is not reasonable for petitioners to ask this court to sustain their mere site argument and validate those speculative concerns. The board assessed the merits of the parties' arguments, considered the evidence in the record, and ultimately used its discretion to allow DC Smoke to operate at 717 D Street Northwest. The board made several specific findings of fact in its 10-page order, which we discuss at length in our papers, all of which are rationally connected to the evidence in the record. It is clear that the board gave great weight to the petitioner's concerns, just perhaps not the heft that petitioners wanted. And as the court in Koff recognized, the board is not required to parrot the ANC's concerns. Rather, it should articulate why the ANC does or does not offer persuasive advice under the circumstances, and then give the ANC's recommendations whatever deference they merit in the context of the entire proceedings, including the evidence and views presented by others. The petitioners are asking this court to accept their speculative concerns as fact. To do so here would afford the ANC and Commissioner Lee undue deference. Finally, as we explained in our opposition to petitioner's request for a stay, DC Smoke was required to open by April 1st, 2025. Practically speaking, what happens if petitioners prevail here? Presumably, DC Smoke will have to cease its operations, put its medical cannabis retailer license in safekeeping, and attempt to find a new facility that is comparable in size, price, and location. And then it will have to go through the application process, the ANC comment period, and the lengthy licensing process again. DC Smoke must spend money to do all of this and will have to absorb these costs. And DC Smoke will not be able to resume operations until its new location is licensed. And what about the substantial amount of money and time that DC Smoke's owner, Tommy Munkinsavith, has already invested in 717 D Street Northwest in order to stand up a licensed medical cannabis retailer? How is Mr. Munkinsavith made whole? The answer is he isn't made whole. This is a very real, not speculative harm. I urge this court to reject petitioner's arguments and to affirm the board's decision to allow DC Smoke to operate as a licensed medical cannabis retailer at 717 D Street Northwest. Thank you, and I'm happy to take any questions from the court.
Thank you, Ms.
Thank you so much.
Mr. Polio, we'll give you 3 minutes on rebuttal.
Thank you, Your Honor. May it please the court. The gravamen of petitioner's argument is that the board made several errors in reaching its decision, both at the hearing itself as well as in the order. And each of those errors are independent bases for the court to set aside the decision and remand for further proceedings. And Your Honor, Judge Kroll, you raised the issue about the great weight, which is our third argument. By statute, an agency like the board is required to not only acknowledge explicitly, but to address with specific reasoning the arguments raised by a neighborhood commission. And that simply did not happen here. And there are several examples, and Your Honor touched on one of them that's potentially the best, is that there was a failure to reference kinder care. If you look back at the neighborhood commission's original protest letter, as well as the protest itself, it said the problem is that this is in close proximity to 3 schools, yet the board's order addresses only 2 of the 3 schools. Right there on its face, the failure to acknowledge that there was a 3rd school, it doesn't even show up on the investigator's map, demonstrates that there was a failure to give great weight and do the things required by statute that it should have done when dealing with ANC's concerns.
I guess the
Additionally-
argument in response to that is that's harmless, or it's clear and you know that the board considered the schools in general. I'm not sure whether the argument by them is that was an error or that it was harmless, but why isn't it harmless?
It's not harmless, Your Honor. I think that, across all of our arguments, one of the issues, one of the themes is the failure to the board to grapple with what it needed to consider when the regulations say you must consider proximity. So for example, in the context of the mere site argument, which counsel for intervener kept raising, so the argument is not a mere site argument, right? The argument that we are raising is that the board was required to consider proximity. And when the board addressed the mere site argument, which again is just putting a label and glibly addressing several different arguments made by the petitioners. It said that the appropriateness criteria does not include any harms stemming from mere site. So what it's telling you is that we actually aren't required to look at mere site, because appropriateness requires us to look at other things. In other words, they didn't consider mere site. And site is a great proxy for, among other things, proximity, right? And it's different what the basis school sees across the street from what Templeton Academy sees around the corner, what the daycare sees 1 block over. And as your Honor was pointing out, it's a variety of things, including the fact that the children not only walk to and from school, but they take breaks and they recess at Navy Memorial. The only thing the board relied on is these hypothetical security plans, but it's so insular, right? They only looked at what was potentially theoretically going to happen inside the facility and gave no consideration to what's happening outside the facility. And that itself is a fundamental error, a failure to do things that the board was required to do. And those are the basis for remand. The other points we quickly wanted to raise, Your Honor, is that with regard to the 30-day filing deadline, counsel for the government says that this is law, but this is decidedly not law. The Supreme Court has addressed the issue in nutraceutical, but this court has not addressed the issue. This court's decision in Mathis is still good law, and it holds that equitable tolling is appropriate in these circumstances. And finally, Your Honor talked about the bad direction that the petitioner received. That was the circumstance that was indicated in Matthews. In that case, the agency had directed the petitioner to go to the Superior Court, and it was through that machination that the court ultimately decided to allow that amendment to appeal. And the last point I'll raise, Your Honor, is that with regard to the 2024 rider issue, the Senate report is important, not just because it's a report, because the report conveys the position from the Department of Justice. And what the report says, the Department of Justice has told us they do not view the rider as prohibiting action. So insofar as whether or not the rider has any effect, and we argue it has none, the Department of Justice clarified through the Senate report what its enforcement priorities will be. And I'll conclude by noting that I think one of the interesting points is in fact that there was an amendment of the law, and the law has no effect on this board's decision. The government seems to suggest that somehow the change of the law, they considered arguments raised by the ANC and rejected them, but that's not the issue before the court, like why the DC Council changed the law. The issue before the court is the board's decision of whether or not it was appropriate. But the one thing the court can take away from the fact that the DC government changed the law, among other things, in addition to repealing the exception relied on here for a 0-foot buffer, it also extended the buffer from 300 feet to 400 feet. And what that shows this court, it shows this court that distance matters, right? There's a difference between 300 feet and 400 feet. That's what the DC Council said, right? It matters, that 100 feet matters. But that's the consideration, the proximity consideration that the board utterly failed to conduct when it just glibly rejected all of petitioner's arguments with a single sentence. Thank you, Your Honors.
Thank you very much. Thank you to all parties for your arguments today. The case will be submitted. Before we adjourn, I wanted to acknowledge a group of students, I think Irish law students who walked in during the last case from the Washington, Ireland program, if I'm right. Thank you for being here. I hope you found this interesting. With that, we are adjourned.
This court is now adjourned.